Mr. O'Regan, you're working with the European Ombudsman, and you've been following this particular policy file very closely. Again, I give you the floor for 8 minutes. Thank you.
Thank you very much for the invitation. I'll use most of my time to speak about transparency, but maybe I would use maybe 1 minute at the end to mention the issue of conflicts of interest, which were discussed by Professor Millstone. First of all, I'd like to repeat the comment of Noel Watlian concerning the fact that EMA has been a pioneer in this area. It is in fact true. If we go back to 2007, EMA was in a position whereby it considered that all clinical study reports in its possession were not even subject to the rules on access to documents. And what we have seen since then are quantum leaps forward in terms of the policy and practices of EMA. Certainly, it's not been a smooth process. There's been a number of stops and starts along the way, but I think it must be recognized that if we look over that period of time, significant progress has been made. Having said that, this is an incredibly important issue where we are still in the middle of a process which hopefully will arrive at an end where the public, professionals, industry and supervisory authorities such as the Ombudsman are content with the situation. But I think we're still in that process, and we're happy in the Ombudsman to be participating in it. I think before I get into the detail of this discussion, I think it's worthwhile just maybe making a few very general points about the nature of this discussion. If we look at science itself, I mean, science, if it is to call itself science, requires that the information and the conclusions on that information are subject to review. You must be able, generally in science, to present the data which you use and allow it to be repeated by third parties in order for that the conclusions that you draw to be verifiable and to be, let's call it, legitimized. And so if we don't have a transparency as regards that particular process, it's very difficult to even call it science. And this is particularly important if the science is directed towards determining whether a product is safe and effective for the use in human beings. It's clearly in the interest of patients, it's in the interest of clinicians and professionals in this area, of the regulators, and it's clearly in the interest of industry that produces these products, that legitimization process of the science, the underpinning the decisions, that legitimization process is strong. So I'm very happy to hear that FPI, at least in terms of the principles, would accept that this is a good process. Clearly it is very important that this paradigm shift as regards the importance and the benefits of transparency are also taken on board by industry. To go into the details of the issue, and I'll be very brief. This is a very broad discussion, but I'll try to be very brief. As regards commercially confidential information, if I just use the example of the AbbVie Humira case. I mean, AbbVie initially argued that the entire CSRs at issue were covered by commercial confidentiality, and the issue, okay, it's already been mentioned, the procedural steps that occurred, this issue went to court. It's now being examined by the Ombudsman. We're breaking it down to very specific justifications as regards whether or not information is commercially confidential, and requiring specific justifications as regards why, in fact, that classification can be used. I think the first important point is to make as regards that process is an issue of timing. What might be commercially confidential at a particular point in time when the data is submitted to the European Medicines Agency is very unlikely to remain so over time. Why? Because the very nature of science is that you are using, normally using standardized benchmarks, which get used again and again to determine whether a particular conclusion can be drawn from data. So if we look at, let's say the example would be testing methods. Okay? You might come up with an innovative testing method, although it is unusual because generally speaking, standardized testing methods are used in clinical study reports. Why? Because they have already been proven to be effective at analyzing data and drawing conclusions. So as regards those standardized methods, no question as regards whether they're innovative. But let's say you do exceptionally come up with a new innovative method of testing. Very quickly, that becomes a standard in the industry. And so we have seen, looking at specific data sets, that arguments are put forward. And when we look at those particular innovative methods and then look at the available information in the scientific, publicly available scientific information, we find the very same tests. Because in the period of time that has passed since the information was submitted to EMA to when the issue of public access is dealt with, that information has no longer become innovative. And that is something which is very characteristic of this particular process. So it is, we say, yes, in principle, if the information is innovative, at the time that the request for access is made, or at the time that the decision on the proactive publication is made, yes, you may be able to convincingly say this specific piece of information can be withheld. But it's very unlikely to be the case in reality. In reality, this information will become, will not remain sensitive over time. And it is very difficult to imagine, and I've looked at quite a number of these documents myself, that you will find other types of information within a clinical study report which could be considered commercially confidential. Why? Because the very nature of a clinical study report is to determine whether or not the specific information, a specific product is deemed to be safe and effective. These are products, generally speaking, which are patented. The conclusions which can be drawn in relation to these particular products, they're product specific. Certainly, and then maybe just raise one other point in relation to commercially confidential information. It is always important that even if an argument is put forward in relation to the commercially confidential nature of information, that must be balanced with the public interest in reviewing such information to determine whether, in fact, the conclusion in relation to the safety and efficacy of the medicine is sound. In other words, a balancing exercise must be carried out. And it is not the end of the particular analysis if an argument is put forward as regards commercial confidentiality. It must be balanced with the public interest in having access to information which is necessary to re-evaluate, confirm whether the conclusion on the safety and efficacy of the medicine is sound. And since these conclusions relate to public health, that balancing exercise would normally swing towards the disclosure of the documents. As regards data protection issues, it is certainly a valid point. But remember, data protection only applies as regards information which relates to an identified or an identifiable person. The information in clinical study reports is already anonymized at source. Okay? So it would only be normally in situations where you're talking about products where the patient group is very limited, so rare diseases, or let's say a pediatric patient population, which may be very limited, that you could realistically be talking about identifying individuals from the basis of the very general descriptions used in clinical study reports. Remember, this is not the raw data. This is the information presented to the Medicines Agency for the purposes of regulatory approval. And generally, the information relating to patients there is already very general. I stress that it is very important that no information relating to an identifiable person be released. But in practice, this, when you look at the information in clinical study reports, it would normally not be possible to identify a person, except possibly in the examples I use concerning rare diseases and, let's say, limited patient groups, pediatric groups, for example. The issue of conflict of interest, and I'll just say one thing about it. It's, of course, enormously important, and it's enormously difficult because we all agree on the principles. The question is, how do you, in practice, determine whether or not an individual is in a conflict of interest? I mean, obvious example, somebody who's worked in an industry for a company which has a particular concern relating to the regulatory decision, that's very easy. Just to give you an example, the Ombudsman has looked at cases where, one concerning EFSA, where the expert concerned had worked for a major university. And the question arose, though, EFSA said, well, look, it's an academic, there's no problem here. But the academic's research was being specifically financed by companies which had a specific interest in the regulatory decision in which that expert was working. So the question then arises whether or not that particular link is sufficiently strong to undermine the independence of the person concerned. At the same time, of course, the regulator will argue, well, we do need the sufficient expertise. Clearly, and I would agree with this point, you can distinguish between providing the expertise and participating in the decision-making process. And I'll make one final point on that. You need to be very careful in that respect also, that you do not create, we have another case concerning the PIP, the issue of the removal of PIPs, or these prosthetic implants produced by a French company which used industrial standard silicone, you know the case. And so the question was whether or not an expert providing advice to the Commission's Committee on Evaluating Emerging Risks was in a conflict of interest. Now, we looked at the file in detail and we found that there was no evidence of any link between the particular person and an interest which would have compromised their independence. But we did point out to the Commission that we disagreed strongly with their point that this person is only an expert advising the committee and is not part of the committee. If they form part of the decision-making process, their specific status within that process is irrelevant. So I just wanted to make those 2 points. Sorry if I went over my time.
That's fine. Thank you very much.